I'm using just won't do that.
Okay, that sounds great. Just a quick introduction for those of you who don't know, the voice you're listening to right now is Nicole Cast, and I'm the CE Program Manager for the MVA, and I'm pleased to welcome you to today's Lunch and Learn session with Dr. Cody Weiberg from the Board of Pharmacy, updating us on recent legislative developments and changes that went into effect about a week ago. If you do have any questions during the session, please type them in the chat area or the Q&A area. Either is fine. I'd like to do a quick introduction. Cody Weiberg received his Doctor of Pharmacy from the University of Minnesota in 1985. He has worked as a clinical pharmacist, community pharmacist, and nursing home consultant. From 1999 until he joined the board in September of 2005, he was the pharmacy program manager for the Minnesota Department of Human Services. Dr. Weiberg is also a clinical assistant professor for the University of Minnesota's College of Pharmacy and an instructor and course director for the University of Florida Graduate School, from which he also received his Master's of Science in Pharmacy Policy and Outcomes in 2009. Go ahead, Dr. Weiberg.
Okay, good afternoon. Sorry I could not get the video to work here, but as long as the audio works, I think it should be fine. And what I'm going to talk about today is really some of the legislative changes that are going to have an impact on veterinarians. And there are actually several that I need to go over today. And we have some additional information on our website. We have an FAQ document that's specifically about 2019 legislation. A lot of the material is not necessarily going to be directly related to veterinarians, but we do have frequently asked questions, or at this point, questions we think we're going to get frequently asked about the overlap with veterinarians. So I think the first thing that I want to talk about, and actually, what I should say first, I think, is that one of the issues that we've had is some of the language that could potentially have an impact on veterinarians is ambiguous. And it's not, it's not clear that some of it actually applies to veterinarians. And so I'm going to go over that and explain why I think it might be a little ambiguous. And but then I'm also going to go over the material for the things that I think are pretty clear cut. So, one of the FAQs that we have in that document is, do prescriptions for opiates have quantity limits? And it is true that the legislature passed legislation language that did create quantity limits for opiates when they're used for acute pain. So that's one thing to point out, is this is for acute pain, not chronic pain. But the way that they wrote the language, the final version of the language, created some of that ambiguity that I mentioned before. So for example, the original version of that language just said that for acute pain, opiates could not be prescribed for more than a 7-day period of time for acute pain. And there were definitions of what acute pain was. There were exceptions where the 7-day limit wouldn't apply. And had that language passed as originally drafted, I think you could make the argument that it would have applied to veterinarians, because there is no language in the bill that specifically creates exceptions for veterinarians. But somewhere pretty late in the session, right towards the end, the language was changed. And what it reads now is that opiate prescriptions for acute pain cannot exceed a 7-day supply for an adult or a 5-day supply for a minor under 18 years of age. And so you can tell right away why this creates some ambiguity. When we're talking in the human world, this is very clear what the legislature is intending. But how do you translate language about adults and minors under the age of 18 to the veterinary world? So I think this creates ambiguity. I think we're going to have to go back to the legislature next session. I'm sure we'll work with the MVMA on this to get some sort of clarity as to whether or not this applies to veterinary prescriptions, if they really meant it to apply. if they did, they're going to have to rewrite this to create a specific quantity limit for veterinary prescriptions, or I think they need to add language that says, well, this provision doesn't apply to veterinary prescriptions. So in the meantime, what we're telling pharmacists, at least, is we're telling them they're going to have to use their professional judgment when it comes to filling prescriptions from a veterinarian for opiates for acute pain. They already have to use professional judgment when they're filling prescriptions for human beings that are for opiates for acute pain, because the language also has a general exception that says that if the practitioner believes more than a 7-day supply or a 5-day supply for a minor is necessary, he or she can still write the prescription for a larger amount if they're using, sound clinical judgment. So we already have to tell pharmacists that if they get a prescription for acute pain that's for a larger amount, they'll have to exercise some professional judgment themselves. Pharmacists have to do that because there is a provision in the Federal Controlled Substance Act that basically makes it the responsibility of the prescriber to make sure that controlled substances are both prescribed and dispensed for legitimate medical reasons. But the very next sentence says, and a pharmacist has a corresponding responsibility to do the same thing. So pharmacists already have an obligation under federal law to question controlled substance prescriptions to make sure that they're appropriate. So you may possibly get phone calls if you have a client that doesn't want you to fill the prescription directly, and you give a prescription for, say, tramadol. Then the client brings it to a pharmacy. They may be calling you with questions about the prescription. And then, of course, it talks about the prescription can't be dispensed for larger than that amount of drug, that day's supply of drug. So if you're directly dispensing, you have to take into account these limits potentially as well. But again, it's really hard to apply, I think, in the veterinary world. And I'm going to leave it up to Dr. Wilson from the Board of Veterinary Medicine to have her board weigh in on what this means for veterinary dispensing. But again, maybe the answer to there would be to use your professional judgment as well. And if it's for acute pain, whether you do larger than, say, 7-day supplies. So that's one issue that I think you need to be aware of. There's also a somewhat related issue. It's a different type of a limit. So I talked about quantity limits. There's also now going to be a time limit for dispensing. And what I mean by that is the legislature passed language that said that no prescription for an opiate or narcotic pain reliever listed in Schedules 2 through 4 can be initially dispensed, so dispensed for the first time more than 30 days after the date on which the prescription was issued. So if a prescription was issued on July 1st, the person would have until July 31st, effectively, to go somewhere and get that prescription filled. So again, I'm assuming if you're dispensing directly from your office, you're probably going to be dispensing it on the same day you're prescribing it or ordering it. But if you do give a prescription out to a client and the client is going to take that prescription to a pharmacy, the client's going to have just 30 days to get it filled. After that, the prescription will be null and void. And so potentially you could get calls from clients and pharmacists in that situation. The other part of the language says that not only does the first fill have to be within 30 days of issue, but each subsequent refill has to be within 30 days of the last fill. So if somebody did get a prescription on July 1st, and let's say they waited for whatever reason until July 10th to get it filled, and that prescription had refills, maybe for tramadol. Well, they have 30 days from July 10th to get the first refill filled, and 30 days from the second refill date to get the next refill filled, and so forth. And so, again, it's possible if you do write prescriptions out for chronic pain, for something like tramadol, and you write something for a 30-day supply with 2 or 3 refills, you could be getting calls because the client hasn't been filling the prescription at least once every 30 days. Let's see. I don't know if this happens in the veterinary world. I was surprised to hear it happened in the world of human prescribing. But apparently there are some pain physicians who will have somebody stabilized on some sort of an opiate, and they're on it on a chronic basis. And what will happen is maybe, again, we'll use July 1st. The person comes into the pain clinic on July 1st. And the way the federal controlled substance regs exist today for Schedule II controlled substances, they can't be refilled. There has to be a new prescription issued each time. Well, one way around that is to issue 3 prescriptions on one day. You have to date them on that day, but you can write a notation in that says don't fill until August 1st, don't fill until September 1st. So in essence, you can write out 3 prescriptions on one day, all dated on that day, but with instructions on the second 2 prescriptions to fill at a later date. Well, that's now in conflict with state law. Those second and third prescriptions would no longer be legally valid because they'd be brought in after 30 days. And again, I don't even know if that sort of prescribing happens, if veterinarians even do that. But if you do issue prescriptions in that way, you cannot do that. You can for something like tramadol, which is Schedule 4, and it can have refills. You can write out prescriptions and have refills. And if you're concerned that the client is using the drugs on them, well, if you're concerned they were using them themselves, presumably you wouldn't prescribe it, but maybe you're concerned that the client is overdosing the animal, giving the animal more than you prescribed, you could write on the prescription, don't refill sooner than every 30 days or something like that. If there are prescriptions that were written before July 1st, which is when those limits went into effect, they are not grandfathered in. And so these new limits still apply to prescriptions that were issued before July 1st. So if you issued a prescription for tramadol, it had refills, and you issued it sometime in June, but the client didn't fill it within 30 days or within 30 days of the last fill, you'd probably get a call from the pharmacy or the client saying, well, I can't get this prescription filled because there was no grandfathering. You may have heard that prescribers now have to check the PMP, the Prescription Monitoring Program, in certain circumstances. That is true, but it does not apply to veterinarians. Veterinarians were not included in the requirement. There was some talk about also requiring veterinarians to report to the PMP, but that sort of language was never enacted as well. So nothing has really changed with the PMP for veterinarians. You don't have to report your own dispensing to the PMP, and you don't have to access the PMP. We will give you an account if you want to have one, but actually most veterinarians, I don't think, find it particularly useful because it's very incomplete data. We don't have any data from veterinarians themselves that are directly dispensing controlled substances. That's not going to be in the system. We do have it from pharmacies that fill prescriptions for controlled substances issued by veterinarians, but that's only a small part of the total data that you would need. Also, you can only, at this point, you can only look up the animal's name and not the client's name. And so until the PMP is actually more useful to veterinarians, I think our board is going to keep pointing that out to the legislature, that creating these requirements for veterinarians to report and use the PMP doesn't make sense until we can make the system work better for you. Let's see, I think it's going to be, well, that's not, pharmacists are going to be able to administer some additional drugs, but those drugs are only for drugs that are injectable and that are used for chemical dependency or mental health, like long-acting antipsychotics. They can only do that with a protocol, with a prescriber, but you know, I don't think you're going to have any protocols with pharmacists to be administering those sort of drugs to animals. Let's see, compounding for veterinary office use. this has been a really important issue for veterinarians, and you may recall that the board worked with the MVMA over the last several years on that issue. State law in Minnesota has actually never allowed a pharmacy to compound for office use. That is, to compound a drug and basically sell it at wholesale to a medical clinic or a veterinary hospital or anything for use within that clinic or hospital. Compounding has always legally required a prescription for a specific patient. Nevertheless, it was happening a lot, compounding for office use, until the big compounding disaster hit. And then our board, the FDA, other boards really started cracking down on enforcing the law. And so a lot of the compounding pharmacies finally got the message that they were breaking the law, and they stopped providing compounded products for offices and clinics and hospitals. But it quickly came to my attention, working with the MVMA and Dr. Wilson, that was creating problems in veterinary practice because, as I characterize it when I go to the legislature, if you're treating companion animals, you might have to treat everything from a 2-pound teacup Chihuahua to, I don't know, a 120-pound Great Dane or however big they get. And for certain drugs that are needed urgently or in emergency situations, there aren't enough available commercial products to get all the dosing that you might need to do. And so what our board did is issue a guidance document 18 months, 2 years ago, maybe even a little bit longer, that basically said, well, even though technically compounding these drugs that were needed for emergencies and urgent situations, even though technically that was illegal, we were going to issue enforcement discretion, and we were going to allow compounding pharmacies to prepare those drugs for use within the office or even dispensing up to a 10-day supply, as long as these were drugs that were truly needed for emergencies or really urgent situations. There were no commercially available products available and certain other conditions were met. Well, I don't like our board to work just on enforcement discretion, basically telling people it's okay to break the law. I think it's best to change the law. And so it took a couple sessions to get this done, but that guidance document is now in the statutes. It's now in law. So now the compounding for office use for veterinary practice, we're no longer just telling pharmacies, it's okay, go ahead, we know you're breaking the law, we won't discipline you. We can now tell them it's legal. As long as you follow these things in the statutes, you can now legally sell these products to veterinarians for office use. Another issue that we've worked with the MVMA on after getting some complaints about it and becoming aware of what was going on is something that involves certain financial arrangements that we discovered were happening between pharmacies and veterinarians. And so in these arrangements, the veterinarian has maybe sometimes a formal written agreement, maybe a verbal agreement, some sort of an agreement with a particular pharmacy whereby the veterinarian is referring clients to that pharmacy. The pharmacy, through a couple of different models that are out there, end up filling the prescriptions. Sometimes the prescriptions are shipped to the veterinary office or hospital. Sometimes they're shipped directly to the client. Sometimes the pharmacy bills the client, sometimes the vet bills the client. But one key feature to all of this is that both the veterinarian and the pharmacy are making money off the prescription. If you take a look at the Board of Pharmacy Practice statutes, we have always thought, since we first heard about those, that those are impermissible fee splitting arrangements on the part of the pharmacy. So we have a law that basically says that pharmacies can't enter into agreements with other healthcare professionals whereby they split the fees. And the reason for that is the concern that ultimately the cost to the patient, or in the veterinary world, the client, is going to be higher than if the pharmacy just filled a prescription and charged the client directly. And so when we heard about these arrangements, no matter how they were structured. And there were some efforts by some entities out there to structure it in a way that they thought made them legal. We actually never thought any of them were legal. So what we did, though, is we worked with MVMA on language that, first of all, it makes it very clear. We thought it was clear before, but now it's very clear that pharmacies cannot enter into those sorts of arrangements with prescribers who are treating humans, right? And in fact, there's a bunch of federal law that would apply there too if those patients actually had Medicare and Medicaid. But it's crystal clear that those arrangements are impermissible. But we've carved out an exception. So it does say that pharmacies can enter into arrangements like that with veterinarians. And then it's further divided between veterinarians who provide services to companion animals and to food-producing animals. So with food-producing animals, the pharmacy and the veterinarian can simply enter into the arrangement, period. They can just enter into the arrangement. With companion animals, the arrangement can exist between the pharmacy and the veterinarian, but the pharmacy has to provide written notification to the client with each and every prescription. A notification on the website is not enough. So it could be something that is printed on a receipt that goes to the client. It could be something that goes in, a separately printed piece of paper that goes into the prescription package that's sent to the client. But the pharmacy has to notify the client that a financial relationship exists. The pharmacy does not, under this compromise that we worked out, the pharmacy does not have to list any specifics about that particular prescription. Now, nothing prevents the client from saying, well, I'd like to know the breakdown. I'd like to know how much the pharmacy received, how much the veterinarian received. They can ask that, and then it's up to the veterinarian and the pharmacy whether or not to supply that information. So the pharmacy doesn't have to go into the detail for that particular prescription or that particular order, but does have to notify the patient that the veterinarian that prescribed the drug and that pharmacy have a financial relationship involving that prescription. Let's see. There's something else that can happen that potentially could affect veterinarians. I suppose you might potentially get calls about it. So for a very long time, our board has exercised another sort of enforcement discretion when it comes to pharmacies facing a situation like this. And this really happened to me the first weekend after I was licensed as a pharmacist, moonlighting in a pharmacy. I have somebody come in on, it was either Saturday or Sunday afternoon, was on a seizure medication and told me that they had very difficult to control seizures and there were no refills. Technically, the way the law read then and the way the law read right up until July 1st of this year, legally I could not have given them a single tablet. What I did was consider that if I didn't give them that medication, they might have seizures, they might lose their license for 6 months, it might be difficult for them to control. So I gave them a 5-day supply and left a note for the pharmacist to go ahead and the Monday pharmacist to go ahead and call the doctor for more refills. So what changed this year is pharmacists are now going to be able to legally dispense up to a 30-day supply of a medication if, one, they have previously filled the prescription for the patient and there's the evidence that the patient's been compliant with therapy, they've been taking the drug as more or less as prescribed. 2, the drug is needed for a situation where if the patient didn't have the drug, there would be very serious adverse consequences. Seizure meds, insulin, asthma meds, things like that potentially. And 3, the pharmacist has made an effort to contact the prescriber to get more refills. And 4, they only do up to a 30-month supply, and they have to notify the prescriber within 72 hours of doing the emergency dispensing and then the prescriber has to approve any additional refills. So you can only do that once every 12 months per drug. And again, to the extent that you prescribe a drug for an animal and the client wants to fill it at a pharmacy, it's for a maintenance medication and you've given refills. If the client waits too long to try to get refills, the prescription's out of refills, and it looks like the animal could suffer, the pharmacist could potentially fill up to another 30-day supply for the animal, but then would have to notify you that that happened. And again, I'm not quite sure how common that would be with veterinary prescriptions. Let's see. Oh, here's another issue. I might not have mentioned this. I can't remember if I mentioned this at the last for the last webinar. But another issue that has, I know, piqued the interest of veterinarians, or that has veterinarians asking questions, is the sale of products that contain cannabidiol, or CBD. Now, after Congress passed a piece of legislation way back in 2014 that authorized, for research purposes only, as part of agricultural pilot projects, it authorized states to permit the growth of industrial hemp. But it made it very clear that what states could do is pass laws that allowed for industrial hemp growth, the growth of hemp plants for industrial purposes, but only for research as part of pilot programs. Nothing in the 2014 agricultural bill allowed anyone to start extracting CBD from hemp plants and putting it into food or dosage forms, or to sell CBD oil or whole hemp oil that had CBD. Nothing allowed that to happen. And in fact, Congress came back in 2018. The 2018 Federal Farm Bill clarified that CBD is no longer a controlled substance, even though it's derived from hemp, which is a cannabis plant. CBD is no longer a controlled substance. It hasn't been a controlled substance in Minnesota since 2015, when Minnesota did pass a state industrial hemp act. But the problem with CBD all along has been not whether it's a controlled substance or not whether it gets you high or not, because it doesn't get people high, although it can cause sedation. The issue is that when you start selling any sort of substance other than food, and you start making treatment claims or prevention claims, if you start saying that the substance can be used to prevent or treat or cure a disease, or if you even start making claims that it can just more generally affect the structure or function of human or animal bodies, like fish oil might be sold over the counter, and it might have this general thing about may be beneficial for your heart. If you make claims like that, then in certain circumstances, that product fits the legal definition of a drug. And the only exception to that is when the FDA has said that it can be sold as a dietary supplement. That's why you can sell things like fish oil or ginkgo, and you can make these structure and function claims as a dietary supplement. You still can't make drug treatment claims, but you can do that if the FDA says you can sell it as a dietary supplement. But the FDA has very explicitly said multiple times that CBD cannot be sold as a dietary supplement. So that means under state law, all of these products that are being sold, and you don't even have to make the claim. Under state law, it's intent. If the intent of the seller and the buyer is that the product is to be used to treat, cure, prevent diseases, or alter the structure or function of human and animal bodies, it meets the state's legal definition of a drug. And drugs are considered misbranded if their labeling isn't approved by the FDA. They're considered adulterated if the manufacturer is not registered by the FDA, licensed by the Board of Pharmacy, and if they don't follow current good manufacturing procedures. So the basic problem with these products all along has been not that they're controlled substances, because that ended in Minnesota in 2015, but they're misbranded and adulterated drugs. That becomes important because our state agricultural department has analyzed some of these products. Some of them don't contain any CBD at all. Some of them contain an amount that's different than stated on the container. Some of them have higher than allowed levels of THC, which actually then does turn them into controlled substances because of the THC content. And so that's been the problem all along. And people, we believe, are making just unsubstantiated claims for benefits that really aren't proven for CBD products. So this has been a big concern, but as I've told reporters who asked me about this, the genie's out of the bottle. Whether these companies should have started making the product or not after that 2014 bill, they did. There are now hundreds of locations in the state of Minnesota where you can physically walk into the store and buy the products. There are maybe thousands of websites, including Amazon.com. Last time I checked, they had 7 full pages of CBD products. So in essence, our board could potentially try to stop the sale of these products. We could embargo the products and prevent their sale. We could try to issue cease and desist orders. The reality is we would not have the staffing and the resources to do that. And so we've been focusing on complaints. And so far we haven't had complaints about it, but if we get complaints that a particular product is causing problems, or that someone is just making really outrageous claims about it, and we get a complaint and we investigate it, we will take appropriate action. But there's just no way for us to stop the sale. Realizing that we're not going to do that, and realizing that it might take Congress and or the FDA quite some time to set some sort of national standards, what we did at the board here at the request of Senator Carla Bigham is drafted legislation that becomes effective January 1st, 2020, and that will make CBD products legal provided they meet certain requirements. And so in essence, the legal products are going to have to be tested by an independent accredited third-party lab to make sure that the amount of CBD stated on the product is actually the amount that's in the product, that the product doesn't contain any contaminants, because the people at the agricultural department tell me that cannabis plants are not only good at sucking up water and nutrients, they also are really good at sucking up herbicides and insecticides and heavy metals. And because this is a plant material, after the plant is harvested and it sits around, if it's not processed correctly, it can become mildewed, and you can have mildew residue. So we're trying to make sure that these products are tested so they have no contaminants, they have the stated amount of CBD. It's an independent lab, and then the labeling has to accurately state how much CBD is in the product, and has to have a statement to the effect that the product is not FDA approved, and there's basically no FDA approval for to treat any particular condition. And then the manufacturer has to, we actually didn't put a requirement in that they have to follow current manufacturing procedures, because we figure if they do the testing reliably, then that will be an indication that the product is being manufactured appropriately. So that goes into effect July 1st. The Board of Veterinary Medicine will have to decide what sort of guidance or instructions to give, I think, to veterinarians. What we are telling pharmacies is that as long as the product meets the new state requirements, we won't take action against the pharmacies selling them, even though technically the products are still violate the Federal Food, Drug, and Cosmetic Act. They're still misbranded and adulterated drugs, at least to the extent that the claims are made. And so what we're going to tell pharmacies is if pharmacies do want to sell the product out of their licensed pharmacy, they're going to be able to do that, but they're going to have to make sure that the product meets the new state standards for testing and labeling. And we're also advising them, because now they're health professionals. They're not like someone at General Nutritional Center that might be selling the product. They're health professionals. And so that means they're subject to malpractice claims. And so, we're telling them they might want to check with their malpractice insurers and with their own legal counsel about the implications of selling these products and recommending them. And the final thing we're telling them is that if they are going to recommend products for specific diseases or symptoms, then we would expect them to have some sort of basis for that. We have a saying with our board: you can't manufacture professional judgment. You can't simply say, well, I'm a pharmacist, therefore I say it's okay to take this product. You have to have a reason for it. And so if we're telling pharmacists, if you're going to recommend this particular product for seizure disorder, you should have some sound evidence that it's going to be effective for a seizure disorder. But at any rate, CBD products right now, as of right now, they're still technically all illegal in the state. They're under the current laws that exist right today. They're misbranded and adulterated products, at least if the intent is to sell the product for health conditions, and I'm not quite sure why else you would be selling the products. But they will be, some of the products, as long as they meet these new standards, will be legal come January 1st. So that's what I can immediately think of. I don't know, MVMA staff, is there anything I've forgotten that you would like me to cover? I'll also take questions. I know last time some people had questions. Actually, questions are coming in.
Yes, there's two questions that I can see. Can you see both of them, Dr. Weiberg?
Yeah, I can.
Okay.
What about online stores that we sell pet foods and supplements? The Board of Pharmacy does not regulate foods or supplements. And so we're talking just about prescriptions that are filled. For example, this is just filled prescriptions. So let's say that you have an arrangement with an online store that might happen to be a pharmacy, and there's some sort of an arrangement that you have, financial arrangements that deals with something other than prescription drugs, over-the-counter drugs, some sort of supplies or devices. We don't regulate any of that whatsoever. It's only prescription drugs that would apply. And we don't have any control over the prices. Again, if that's all part of that same question, what I'm talking about is only for prescription drugs that are filled as a prescription by the pharmacy. And let's see. Oh, checking identity. Yes, I did forget that one. Can we only give to the owner? No, the law does not say that. So, yeah, there's a new provision that you could actually make the argument that it's actually always potentially applied to veterinarians, although it does talk about patients rather than clients. But there's been a requirement on the books for quite some time that applied only to Schedule 2 and 3 controlled substances. And it basically says nobody can dispense. That's why I think you can make an argument it actually maybe already applied to veterinarians. It says nobody can dispense, it used to say nobody can dispense Schedule 2 and 3 controlled substances without checking valid photographic ID of the person who's picking it up, basically. It doesn't say, in fact, it specifically says it doesn't have to be the patient or for whom it's prescribed. It can be somebody else. But there were exceptions built into it. Basically, one exception was it only applied to cash-paying customers. So in the human world, if it went through insurance, you didn't have to check. And that was put in there presumably because almost everyone gets their prescriptions in the human world filled by a pharmacy, but paid for by a pharmacy benefit manager under contract to their insurer. And all the PBMs have built into their claims processing software ways to determine if people are getting the drugs filled too soon in their doctor shopping. That was the rationale for it. The other exception was if you know the person who is picking up the drug, you don't have to check their ID. So what the legislature did now was, because there was maybe a little ambiguity as to whether or not this applied to veterinarians, now it clearly does. They also expanded it to all controlled substances in all schedules. It's not just opiates like we've been talking about. And it does say you have to check a valid photographic ID. It wouldn't, I don't know that it would have applied to you, although I guess there is some pet insurance now. But the thing is that that exception that made it apply only to cash-paying customers is gone. The other exception is still there, though. It basically says if you know the person who's picking it up, if this is a client of yours who's been coming to your clinic for years, you don't have to check the ID. The other thing that it doesn't require that's come up is it says you have to check a valid photographic ID. And there's actually two things, the questions that are coming up here. It says you have to check a valid photographic ID. Unlike the pseudoephedrine laws, which I think say it has to be a valid government-issued ID, it doesn't have to be a government-issued ID. So I think most commonly it's still going to be a driver's license, or for people that don't drive, a state-issued identification card. But it could also be a passport, which of course that's government-issued too. But it could be maybe a college ID for a college student. It could be a workplace ID. As long as it has a photograph and the name of the individual, it could be that sort of an ID as well. So that's one question that comes up. The other question that comes up is it says you have to check the ID. It does not say you have to make a copy of the ID. It does not say that you have to keep a log indicating that you checked the ID. So again, what we're telling pharmacists is no, you don't have to make a copy of everyone's driver's license. You can, but you don't have to do that. No, you don't have to keep a log that says I checked for the ID for these controlled substance prescriptions. We are, however, reminding pharmacists of something that happens in the pharmacy world that maybe wouldn't be much of a problem with veterinarian dispensing, but we actually get at least a couple of complaints a year, and this almost always involves controlled substance, where someone says that they went up to their pharmacy to pick up their oxycodone prescription, and it wasn't there, and the pharmacist said, well, we already dispensed it to you. When in fact, they never went to pick up the prescription, and they never sent anyone to pick up the prescription. And it's hard to know exactly how this happened, but in a few cases, we sort of track things down, and we think that the person, like I remember one case in particular, we think what happened is the person actually mentioned to one of their neighbors, oh, I got to go pick up my prescription. The patient knew the person was a chronic pain patient and beat him to the pharmacy to pick it up. And so what we're telling pharmacists is, no, you don't have to keep a log. You don't have to make copies of the ID. And we understand why you might not want to make copies of the ID. Patients might really object to you making copies of their driver's license. But you might want to keep a log. You might want to have something that indicates that you did check the ID, or that you didn't check the ID because the patient was known to you. Because if we do get a complaint like that, you can use that as your defense. Look, we have evidence that we checked the ID. So, yeah, I think that kind of covers that issue. Other questions, other topics I didn't remember to cover here?
Could you just re-clarify with the new law and allowing refilling life-saving drugs for an additional 30 days if there are new refills remaining? Does that apply to controlled substances, such as?
No, it does not. I'm sorry, no. It does not apply to controlled substances except for what these days I think is a very limited category of controlled substances that are used to treat seizure disorders. And then the pharmacist can do up to a 72-hour supply. So occasionally, at least in the human world, But some benzodiazepines are still used for some types of seizures. There may still be the occasional person on phenobarbital, although I think that's very rare. But that's the only exception for controlled substances, is controlled substances used to treat seizure disorders.
Thank you.
Yep.
I have one question that came in to me, and I don't think you can see it, asking about fees increasing for vets that need DEA to script to what cap?
There are no fee increases for veterinary, not from at the state level. So one of the things that we proposed to the legislature actually was part of the governor's budget, because the board was sort of given this task by legislators, and the governor, when he was coming into office, I think made it clear that opioid abuse was a big issue for him as well. And so we were asked to develop some sort of a mechanism for generating revenues to help deal with the opioid crisis. And so what ultimately passed, and there's a little implication here, I forgot to talk about this, I'll talk about this too, but what ultimately passed is the fees of many of the businesses that are board licenses were increased from as little as $110 a year to $5,260 a year. The only type of facility that did not see a fee increase was pharmacies, and I don't know why they weren't included. And then we are also supposed to collect from opiate manufacturers. We're supposed to collect data from them, and any opiate manufacturer that has more than 2 million of their units, capsules, milliliters, grams, whatever, patches, more than 2 million units used in Minnesota, they have to pay an additional $250,000 fee. That's what passed, and I'll get back to that in a minute. But one of the things that the board put out as a proposal, as an alternative, which would have been administratively somewhat simpler to do and would have been less likely to get us sued, although so far we have not been sued as what's been put into place so far. New York passed a law and was sued and lost the case. So one of the things that we proposed was to do what 26 other states do, which is to have the state equivalent of a controlled substance registration system, of the DEA registration system. If that would have passed, then prescribers and pharmacies and drug manufacturers and wholesalers, any business or individual that was somehow involved in manufacturing or wholesaling or dispensing or prescribing controlled substances would have paid a state controlled substance registration fee and been issued a state registration number. Veterinarians, if would have been, along with all of the practitioners, and the various amounts that were kicked around were anywhere from $75 to, I think, about $150. But none of that passed. It didn't even get a hearing. So there are no increases on, there's going to be no requirement for veterinarians to get a state-controlled substance registration or to pay any fee for that. And none of the licensing fees apply to veterinarians because we don't license veterinarian clinics and hospitals, so none of that applies. So there aren't going to be any direct fee increases. Now, in theory, although I don't think this is going to happen, in theory, if you had a manufacturer that sold more than 2 million units of opiates in the state that also manufactured veterinary drug products, they might have to pay that $250,000 fee. And the concern was, would that get passed on to veterinarians and would the prices of the products go up? Well, so first of all, that $250,000 fee, we were able to identify with our PMP data, Prescription Monitoring Program data. We think we already know the roughly 15 companies that are going to have to pay that fee. And I don't think any of them produce any veterinary opiate products, and maybe no veterinary products at all. The other thing is our licensing fee part of it, it is clear that any manufacturer of any drugs and any wholesaler of any drugs is going to have to pay a $5,260 fee, and that would include manufacturers of veterinary drugs. But the way the legislature structured the fee half of this is they said that what they really said is every manufacturer except opiate manufacturers have to pay $5,260. Opiate manufacturers are going to have to pay $55,260. But because of the way they structured that particular section of the law, I don't think the $55,260 fee applies to a manufacturer of veterinary opiates, as long as that manufacturer doesn't also produce human opiate products. And I think a lot of the manufacturers that do veterinary opiate products, my understanding is if their general corporation does both human opiates and animal opiates, it's different divisions. It's different companies. There may be one umbrella company that owns it, but each of the companies that works in the veterinary world and the human world are separately licensed companies. So the upshot of all this is I don't think the veterinary manufacturers of opiate products are going to have to pay the $55,260 fee, and I really don't think they're going to have to pay the $250,000 fee. The fee will go up to $5,260, and as I pointed out to the legislators, manufacturers get their money from selling the product. So is there a potential for the price of the product to go up? Yes. But if you're taking $5,260 and dividing it by all the units sold into the state, hopefully the price wouldn't go up very much. Review new requirements for written controlled substances. Well, there's the quantity limits I mentioned before. Because of the time limits I mentioned, one of the things that you can't do, and I think I already talked about this, is you can't write like 3 prescriptions out on one day and date them sequentially. Otherwise, the requirements for the prescriptions, they still all have to have the patient's name. In the veterinary world, I think you have to have the species of the animal. There's certain requirements that apply to all veterinary prescriptions. You have to have the drug name, the drug strength. You have to have the quantity. If you're going to do refills for schedules, 3 through 5, you have to indicate the refills that you want. You have to manually sign the prescription if it's on paper, which I think most veterinary prescriptions would be if you're going to give them to a client. I don't think you're going to electronically prescribe them and send them to the pharmacy. But other than that, I think that's it.
I had a individual let me know that they received a email from vetmed@state.mn.us, which I'm going to guess is the Board of Veterinary Medicine. Yep. That it was stated in an email that they were told that proof of identity check should be captured in the medical record. So it sounds like Dr. Wilson might have weighed in on her recommendation regarding that.
Yeah, and you'd have to check with her to see if that's what the VetMed board wants to do. That is from them, and I did review that. And yeah, I'm going to defer to them, obviously, about how they want to regulate veterinarians. So what I'm doing is just kind of like the old Dragnet show, just the facts here. And so what the facts are is that, and again, we are telling pharmacies, it'll be a good idea for them to have some sort of a log to prove that they've checked the identity, but technically nothing in the statute actually requires that.
Thank you.
Yep.
I had another question asking if the state is considering banning any certain drugs.
No, we're not. The closest that not to banning it, not any FDA approved drug. We have the Board of Pharmacy has worked to ban hundreds of different, synthetic cannabinoids and hallucinogens and stimulants and fentanyl analogs and things, but those are all Schedule I non-approved FDA drugs. So the board hasn't proposed to ban anything. I've never seen any legislative proposals to ban an FDA-approved drug. We did ask the legislature to consider scheduling gabapentin, but that did not happen, and that's because we are seeing a really large amount of gabapentin abuse in two different ways. Methamphetamine users will also use gabapentin because they continue to get the high that they want from the meth, but the gabapentin dulls some of the adverse reactions they get from meth, so they feel high, but they don't feel sick, apparently. And then gabapentin itself is being abused for just for its own effects, and also being abused. I guess a third reason I've heard that it's being abused with opiates to potentiate the opiate effects. And we're seeing a lot of it in north central Minnesota and down in the Mankato area. And at least one other state has scheduled it, and other states are considering it as well. But that did not happen. But that wouldn't have been banning it. It would have been scheduling it. And we were only going to put it in Schedule 5, which meant it could have been refilled, and the refills for Schedule 5 can be for up to a year. So it would have been more of a law enforcement thing. If you put it in the Schedule 5 and people really are selling it on the street, then law enforcement could have prosecuted the dealers. But that didn't happen anyway.
A couple more questions. Can an associate or relief veterinary work under the owner's DEA license? Or to prescribe, dispense, must they have their own DEA license?
Well, so are you talking about another veterinarian working under a veterinarian, or are you talking about non-licensed people? Obviously, the only people that can ever prescribe are licensed people. Now, if you're talking about, does every veterinarian at a clinic maybe have to have a DEA? We at our board, at our board, we would have thought the answer to that was yes, but I guess it's pretty widespread out there that that's not always the case, so I think we would defer to the DEA in this regard. There's no state controlled substance registration. All our laws about prescribing controlled substances, with some of the exceptions I just mentioned today, which were just enacted this year, pretty much just defer to the federal law. And it says, you have to, obey the Federal Controlled Substance Act and its regulations. Again, it was our understanding that except for limited circumstances, for example, there's clear language in the DEA regs that says in a regular hospital, human hospital, that the hospital itself, not like the chief medical officer, the hospital itself can have its own DEA registration, and that registration can be used by the residents and interns that work in that hospital. And what they have to do is they have to develop internally a 4-digit suffix that goes at the end of the letter for each person. So you might be a resident and you're using the hospital DEA number, and your suffix is -1010 or something like that. That's permitted. I'm not sure if that applies to veterinary hospitals or not, to tell you the truth. And so we always thought you needed a separate, every prescriber needed their own separate DEA registration, because generally the DEA wants the person whose number is being used to be directly responsible for that prescription. So again, I'd actually encourage people, veterinarians who have a question about that, to call the local DEA diversion office and ask what they think about that.
One last question about gabapentin. Could you tell us where to find information about gabapentin if it needs to be locked in a safe and accounted for similarly to scheduled drugs?
It doesn't. It's not scheduled federally, and it's not scheduled under state law, so it does not have to be treated as a controlled substance. No special storage, no special inventory requirements, nothing like that at this point.
I think that's all the questions I have seen. If anybody does have any further questions, you can either email them to me or to Dr. Weiberg, and we will help get those answered for you. Dr. Weiberg, thank you very much for your time today.
Welcome.
I know this is very important to our members. For those of you who want to re-listen to this, I will repost. I've been recording this session. I will repost it and let you know when it's available, but it does take me a little bit of time to get that done, so it probably won't be until tomorrow. For those of you who want to know, I will be sending a link to the evaluation, and your CE certificate will also be emailed to you. Thank you very much, everyone, and have a great day.
All right. Bye-bye.